It is a pleasure for me to join the HCCH celebration on the 25th anniversary of the 1996 Child Protection Convention. I would like to thank Sherry, the Permanent Bureau, and the Regional Office for Latin America and the Caribbean of the Hague Conference for their invitation to be part of this event. I believe that every anniversary could be seen as an opportunity to review and to reflect on achievements, remaining challenges, and future projects. Because of this, I would like to take the next minutes to share with you some of the achievements and challenges that the 1996 Hague Convention posed in Latin America. If you are going to reflect on child protection in Latin America, it is compulsory to consider the impact of human rights in private international law solutions. Human rights treaties, and particularly the UN Convention on the Right of the Child, brought a reformulation of national constitutions and domestic laws in several countries. Thus, over the last decades, family law and child protection solutions have been greatly influenced by this advancement. In addition, the doctrine of the Inter-American Court of Human Rights reinforces this impact, especially taking into account the peculiarities of this system. It should be noted that the Inter-American human rights system allows to condemn countries for the violation of human rights, but also to impose obligations both in each specific case and in general, including, for example, the training of judges in human rights, the improvement of domestic legislation, and so forth. In this context, important work has been done in the region in order to fulfill human rights in the field of child protection, both at domestic and regional level. As a result of this work, a multiplicity of international conventions for the protection of children were developed. Two main scopes should be considered. Regionally, several instruments were elaborated within the Inter-American Conferences of Private International Law, known in Spanish as CIDIPs, which have meant an important contribution and have captured the Latin American approach in their solutions. These instruments have also served as an inspiration for domestic regulation. However, there are no instruments within this scope that specifically cover parental responsibility. Globally, the work developed by the Hague Conference is remarkable, not only because of the process of developing conventions, but also because of its post-convention services. These aim at improving the convention's effectiveness. In addition, the work developed by the regional office has had an impact on the dissemination, identification of good practices and challenges for the implementation and operation of the conventions. It does so with a particular focus on the Latin American approach and realities prevalent in the region. Notwithstanding the importance of the richness of the existing solutions, it should be recognized that there are still challenges in order to provide effective solutions for real cases. In the 1996 Hague Convention should be seen as a protagonist in this goal. If we focus in this instrument, both benefits and challenges should be considered. We are going to review some of them. Its benefits will be at the core of this global event, and they are twofold. In the first place, there are the unified solutions regarding cross-border cases on parental responsibility, such as jurisdiction, applicable law, and uniform rules on cooperation and coordination. In addition, the broad material scope of the Convention includes custody and contact, measures of protection, situations in which parental responsibility is unavailable, non-accompanied children, displaced children, as well as children's property. This means an important rights recognized to the child will find a way to be restored or enforced. In the second place, the 1996 Hague Convention should be considered as a tool to achieve the objectives and the cooperation that the 1980 Child Abduction Convention promotes. For example, An important challenge that courts are facing nowadays is how to address domestic and gender-based violence in international child abduction cases. The 1996 Hague Convention may contribute to the possibility to adopt protection measures and to facilitate the post-return assistance. This would contribute in pursuing the harmonization of the protection of the rights of both children and the abducting mother without confronting them. In addition, the 1996 Hague Convention is also applicable in international abduction cases when the 1980 Convention is not enforced among certain states. Notwithstanding all these benefits, the 1996 Hague Convention was signed and ratified only by some states in Latin America, despite the fact that several years have passed since it entered into force. At the moment, 8 countries are part of it: Costa Rica, Cuba, Ecuador, Honduras, Nicaragua, Uruguay, Paraguay, and Dominican Republic. More countries are considering joining it. Probably 2 main aspects may give an answer to discuss ratification of this instrument. Firstly, the possible shortcomings or difficulties to understand the complexity of some provisions. Secondly, the challenges and shortcomings at the time to approve or ratify the convention, taking into account the administrative and judicial reality of some countries because of the lack of human resources to study and analyze them deeply. Both types of difficulties can be overcome in practice, as experience has shown. Regarding the complexity or novelty of some provisions, I will mention some challenges that were captured in the explanatory note on specific matters concerning 1996 Convention drafted by the Permanent Bureau after the meeting held in Santiago de Chile in 2013. 1. The determination of the habitual residence of the child as a main connecting factor and basis for jurisdiction. Traditionally, domicile has been the most frequent connection factor used in Latin American countries. Nevertheless, the habitual resident is also a broadly familiar concept because it is provided by other conventions. 2. Concerns surrounding jurisdiction, particularly to the positive and negative conflicts on jurisdiction and transfer of jurisdiction. In these scenarios, communication and coordination between the competent authorities of the countries involved will be the key to the proper functioning of the provisions. However, such coordination is not common in Latin American states. In general, Latin American judges are reluctant to share or discuss these kind of issues with others. On a positive note, it is worth mentioning that direct judicial communication with the assistance of the central authorities in both states or of the judges of the international network are increasingly successful. 3. Concerns surrounding protective measures, especially because they are not qualified and cover a wide range of situations. In this regard, the work developed by the Hague Conference and the Academy and the experience of those countries that have been applying this convention for a long time should provide clarification. 4. Recognition and enforcement of a foreign measure of protection. This could mean a novelty in some countries and may lead to some procedural concerns. In any case, it is important to recall that this provision seeks the effectiveness of the measures in order to protect the integrity of the child and the rights involved. Among the challenges posed for the approval or ratification, as well as for the implementation of the convention in some countries of the region, we find 4 different needs. First, the need for dissemination of the convention, both for the acknowledgement of the instrument and its benefits in order to become part of it, and for its proper application in a later stage. Second, the need for training. In several regions of Latin America, judges do not decide on international family cases very often. Thus, they are not aware of the current tools at hand and how to apply them. If they were made aware of an applicable convention at a later stage, the answer would probably not be on time, and this would have a negative impact on the best interest of the child. Third, need for resources and designation of central authorities. The Convention imposes upon states the obligation to designate central authorities. In almost all Latin American states, central authorities are designated under the 1980 Convention. Thus, this mechanism is not a novelty in the region, although the functions between them differ, especially because of the material scope of the 1996 Convention is wider and calls for more coordination and flexibility. At a later stage, the need for economic, human, infrastructure, and technological resources, among others, will also be a challenge. Fourth, need of domestic procedural tools in domestic regulation to ensure the effective implementation of the cooperation system that the 1996 Hague Convention provides. For example, some states should adopt simpler and faster procedures to enforce or register provisional measures or to deal with urgent measures in a more efficient way. Notwithstanding the responsibility of states in facing these challenges, the contribution of the regional office, the academia, as well as the proper intervention of the judges of the international network could aid in the search for the proper protection of children's welfare. And what about the Latin American actual experience? In a nutshell, limited but successful. It is limited because of the scarce ratification status of the Convention. Besides, judges and other judicial operators and legal practitioners do not usually have enough knowledge and training in private international law cases. Moreover, our research on this field is based mainly on the information shared by central authorities and the regional office, since there are not a lot of court decisions that have applied the Convention, or they are rarely published. It becomes evident then that cooperation among central authorities has been one of the most beneficial tools of the Convention. According to their opinion, for the moment, the Convention has been mostly applied in order to get protective measures in international abduction cases, especially for the enforcement of return orders. In other words, the instrument is mostly used as a complement to the 1980 Hague Convention. Nevertheless, some other areas have benefited from the provision of the 1996 Hague Convention. Among them, custody, visitation, requesting information of personal and family situation of the child or of the protective measures in the other states. Protective measures for non-accompanied children, for example, from Venezuela to Ecuador. In most of the cases, Latin American states can and do intervene both as requesting as well as requested states. As a conclusion, much work has already been done in Latin America region in the international family law sphere. The 1996 Hague Convention brings a lot of tools in order to fulfill children's rights. Some challenges are posed in order to join and apply this convention, but the experience has shown that they could be overcome in practice and that the effort is worth it. Synergy amongst academia, authorities, and other stakeholders need to be consolidated and bolstered to achieve that goal. Thank you very much.